Okay, awesome. I am going to leave my camera off this morning. For the first session, I had some issues with the internet and I was freezing while I had my camera on, so I'm going to leave it off. Unfortunately, you won't be able to see my glowing face. It's so sad. But yeah, today we're going to go over the Utah Stormwater Law that went into effect January 1st. There have been changes to the law that were made in the most recent legislative session, and those will go into effect on May 1st, which is in 2 days. So I'm not going to distinguish between what was in the law before and what's going to be changing on May 1st. We're just going to go over the law as it will be in effect in 2 days. If you have any questions, we will have a couple of minutes at the end for questions, but I'm going to try and go through this as quickly as possible to not take up too much of your day. But we will have a couple of minutes for questions at the end. I will also put on my my contact information. So if you have any questions, please feel free to reach out to me via text or email, or and we can answer any of your questions. Now, to get started, this is we're going to talk about exactly what's in the Utah Stormwater Law that went into effect this year. I am not a lawyer. I have had many conversations with our attorneys about the definitions and about what's going on in this law, and I'll be giving you, what we have come up with. But if you are running into any issues or you have any questions about interpretation of the wording of the law or anything like that, I would highly advise that you reach out to your own attorneys, because I can't, I can't give you any legal counsel or advice on it. But I am going to go over exactly what's in the laws here. So the the new law actually revised 4 different Utah codes. We're just going to go over the first 2. The last 2 Utah codes that were revised mainly have to do with fines for neglect and for intentional harm to water and water quality and things like that. And so I'm not going to get into those. They don't change a whole lot from the previous stuff anyway. But I am going to go into the first 2, which talk specifically about the requirements and the rulemaking authority. So the first one that we're going to talk about is Utah Code 19-5-105, which is titled Rulemaking Authority and Procedure. Now, to give you some background on this law was mainly backed by the Utah Home Builders Association, and their goal in this was to help provide a uniform experience for stormwater regulations for builders throughout the state. There had been over the years a lot of grumbling and a lot of complaints and a lot of concern that when builders would build in one city and then use the same techniques, use the same forms, use the same everything else in another city, that it wouldn't be accepted, that there would be additional requirements, and it was unclear what requirements were being used by who and what the actual regulations were. And so the UHB lobbied for this legislation. Okay, so it looks like Robert is not able to hear me. Is anybody able to hear me? Okay, it looks like most people can hear. Let me turn up my mic a little bit. I'm not sure, but okay. So that was the goal behind the legislation. I'm not sure what the issue is with Robert. Okay, so that was the goal behind the legislation, was to kind of make it uniform across the state so that everybody knew what to expect and what they needed to do regardless of what city that they were in. So the first Utah code that had changes here in the new law is code 19-5-105, and basically what it says is a municipal system may not make requirements more stringent than federal regulations. And then it gives 3 specific instances where a municipal system may make changes or may make requirements that are more stringent than federal regulations. And specifically, the rules are, if you have, if your municipality, if your city has issues that require more stringent regulations, then you have to submit public health findings, public health information and studies and findings supporting that. And then those findings need to go through a public comment period and a hearing. And then once that is all completed, then those more stringent requirements can be implemented. But unless those, unless that public comment period and public hearing and those findings are provided, then the municipalities can't make requirements that are more stringent than federal regulations. The second exception is if the rules relate to agricultural water. And the third is if it is a UDOT project and UDOT is making requirements for those projects because of a consent decree that they are operating under with the EPA or with the state, but probably with the EPA. So if UDOT is operating under consent decree and they're making requirements for their projects to meet the requirements of that consent decree, then obviously they can have requirements that are more stringent than the federal regulations as well. Okay, so that is the first one, 19-5-105. The second law that was affected is 19-5-108.3, which specifies exactly, what can be required for construction site stormwater runoff controls. So we're going to jump right into that. So the gist is that the requirements, again, cannot exceed the federal or state standards. And that the requirements are clearly listed. So this requires municipalities to have requirements that do not exceed federal and state standards, and also that they list their requirements on their website. So Part 2 specifically says the authority. Now, when we mention the authority, that's the language in the law is the authority. There's a definition for the authority, and that talks about the municipal separate storm sewer system, so the MS4. And then in this latest update of the law, it also includes some aspects of the Department of Water Quality. So the authority may not make or enforce a rule, ordinance, or policy regarding the municipal system more stringent than the corresponding federal regulations under the Federal Clean Water Act, unless it is expressly permitted by state statute. Our state statutes in Utah typically do not exceed the Federal Clean Water Act. I can't really think of a case where they do, and so really, both of those are basically the same. If you don't exceed the Federal Clean Water Act, then you're also not going to exceed state statute. The issue that has come up here is with the ordinances. A lot of municipalities already have ordinances in place that exceed the regulations or that are more stringent than the regulations under the Federal Clean Water Act, and so those will need to be changed or updated in order to no longer be more stringent than the corresponding regulations. The next, Section 3, each authority shall determine the authority's preferred best management practices. This is having the municipalities or the cities that are regulated as MS4s come up with their own list of preferred BMPs, stormwater controls, stormwater best management practices. They also have to publish those on their website. Now, the state has come up with some help in that regard in terms of kind of an overview or a manual or some guidance. And so a lot of the cities are going to be using the guidance that they've received from the state to make those changes and update their websites. And number 4 is very similar as well. And this is maintaining a list of requirements to make a complete application for a prevention plan approval, which is a SWPPP. So for your SWPPP approval, and the municipalities need to publish that on their website as well. The state has provided a checklist for SWPPP reviewing for a SWPPP review that goes through every requirement in the permit and lists with that the specific section of the permit where each of those requirements are. And so it's a great tool, and most of the municipalities it appears are going to be using that state provided SWPPP review checklist, which I think is great. It makes it very convenient, very easy for anybody anywhere in the state. They know as long as their SWPPP includes everything in that list, that they're good to go. And so I think that's a great tool there. Cities do not have to use that checklist. They can provide their own checklist. But again, the rules in their checklist can't exceed the state, federal or state requirements. And so, it should be requiring pretty much the same stuff as what's in that checklist. So you should be good to go regardless of what city you're in, using the state's published checklist, because those are the rules straight out of the permit. So, from what I've seen, most municipalities are going to be using that checklist as well. So again, we mentioned for that checklist, the Part 5 specifies that list of requirements, even if they choose not to use the state's list, can't exceed the application requirements of the Code of Federal Regulations, Part 122, Subpart B, which is under the National Pollutant Discharge Elimination System requirements. All right, so let's talk about SWP reviews. So that checklist needs to be published, and the state has put that out. If every municipality may not have that up on their website just yet, but the state has published that, so it is available. Now, when the SWP is submitted to the municipality for review, the municipality under this law now has 14 business days to review the SWP and respond to the applicant, to the contractor. They may request more information or modification to the prevention plan if it is missing something that is in that checklist, as long as the request specifically lists why the prevention plan is non-compliant. And for any requested modifications, it must include citations to the permit requirements, local ordinances, state law, or federal law that require the modification to the SWP. Again, if the city is using that list, that checklist that was put out by the state, that'll be very easy to include those citations, because the references to those specific sections are in each of the checklist bullet points in the checklist that the state has sent out. And so if the city's using that and they find anything missing, it'll be really easy to go ahead and put that reference in there because it's in the checklist. Once that is submitted, once that those modifications are requested and the changes are made, and then the municipality it is resubmitted to the municipality, then they have another 5 business days for the second review of the SWP, and then they need to notify the applicant in writing whether the authorization to discharge is granted. Now, it's unclear, the law does not specify beyond that. So if the second review of the SWP also finds that the SWP is still missing information because the checklist, because the modifications were requested and those modifications were not made, or only some of the modifications were made, and so the municipality does not grant the authorization to discharge, there's no further stipulation in the law as to what happens after that. So I don't know what to tell you about that, but there are no stipulations except that the city can just say, well, your SWP is rejected, I guess, and then you guys can come up with a plan for how to move on from there. But there's no stipulation in the law after that second review for 5 business days. Okay, so let's talk about escalating enforcement. One of the other things that this law did was that it standardizes the escalating enforcement actions that are available to municipalities. Previously, municipalities had to come up with their own escalating enforcement actions. Actually, it's still a requirement for municipalities under their MS4 permit, but under this law, it's kind of just laid out exactly what that can be. This changed a little bit from previously, from what was implemented January 1st. And so this escalating enforcement timeline and procedure goes into effect in 2 days. It starts on May 1st. And so the timeline for this is once the violation is noticed, once the municipality notices the violation, then they must notify the operator in writing of that specific violation. Now, the municipalities are going to want to be very careful to separately list every individual violation because the law is very concerned about these violations being specific violations. And so what you'll see when receiving this notification from a city is a very specific list of each violation. You may see a separate violation for track out for each lot number, for example, or something like that, to make sure that it's very clear which violations are being called out. Now, the notification in writing does not specify that it has to be, a printed out sheet of paper. This can be from what we have discussed with our attorneys. This can be via email. This can be via text message. This can be any type of a written notice. that is received by the operator. But the municipality notifies the operator, and then they provide at least 1 business day to correct the violation. So at a minimum, the violation must be corrected by the end of the next business day, and then the violation has to be verified if it has been corrected. So that can be with the operator sending picture evidence to the municipality or to the regulator, or the regulator can come out and check to make sure that it has been corrected. In either event, if the violation cannot be verified to have been corrected, then another notice must be issued to the operator. That second notice needs to provide at least 1 more business day to correct the violation, and will also inform the operator that fines may be assessed if the violation is not completed in that 1 more business day. So after that 1 more business day is over, then the violations, the violations need to be verified again to make sure they've been corrected. If those violations still have not been corrected after these 2 business days, then the municipality will notify the operator in writing again that the violations have not been corrected, and at this point they can impose a fine for each occurrence of each specific violation for each day. Okay. The fines are listed here on the screen, but you can see, you have $300 per occurrence, and that is per occurrence per day for tracking mud on the road. So if the municipality, specifies each lot that has track out that needs to be taken care of, and you have, 10 lots that have track out, each of those specific violations, when not corrected after that 2-day period, could be subject to $300 per occurrence per day. So that's, $3,000 per day for 10 specific violations, right? So very important that once you have received that written notice, that you make sure and clean up those issues, because there's no direct, there's nothing saying exactly what a specific violation must be. So again, it could be track out for every individual lot or something like that. So those are the fines there. These are these specific fines. No other fines, we'll show this later on in the law, but no other fines other than these can be levied. But again, a lot of these can be combined. If you have track out, and the reason you have track out is because you have a failure to use BMPs, then not only is that a violation for the track out, but it's also at the bottom, the $500 per site per occurrence for failure to use BMPs. If these can be stacked up with each occurrence for each specific violation. So you'll want to make sure that you're on top of getting those violations taken care of. Okay, Section 7 talks specifically about stop work orders, and this is where the preferred list of BMPs from the municipality comes into play. The preferred list that is published, the preferred list of BMPs that is published by the municipality, does not have to be used. There's no requirement that the contractor uses the preferred BMPs. If you have a stockpile of BMPs that you want to use, and they are effective and they will do the appropriate job in that situation, then those you can use other BMPs that are not on the preferred list. However, the reason for using the preferred BMPs that is published by a municipality is because if there is a violation that results from a deficiency in that preferred BMP, and you have installed it correctly and maintained it correctly, then you cannot be issued a stop work order because of the violation that results in a deficiency from that preferred BMP, right? So a couple of things there. If you choose that BMP that's on the preferred list of the municipality, you implement it correctly and you maintain it correctly, and it still fails for some reason, and there is a violation, then you can't be given a stop work order due to that violation because you use the preferred BMP. Okay, so that is the benefit to using the preferred benefit BMP, I guess you can say. So when can a municipality issue a stop work order? And a municipality can issue a stop work order if they have a clearly documented reason articulating an immediate threat to water quality. So what does immediate threat to water quality mean? The law defines immediate threat to water quality as pollutants entering a water body. pollutants entering the water. So if there is a discharge from your site of sediments or other pollutants, and it is visibly entering a water body, then the municipality may issue a stop work order for that. The only time that they can't is if you have implemented the preferred BMPs correctly, maintained them properly, and the immediate threat is a result of a deficiency from those preferred BMPs. Okay, so a stop work order can be issued for immediate threat to water quality, and then you will be given the violation and be asked to clean it up, to fix the problem. If the problem is not fixed within that escalating enforcement period of 2 business days, then the municipality can fix the problem and recoup the reasonable costs incurred to correct the problem after that, enforcement escalating enforcement procedure has been exhausted. And then finally, Section 7, subsection H, the authority, the municipality may not impose a fine for any reason except as provided in this subsection. Okay. All right. We're going to finish up here with some of the other requirements that it talks about. So first of all, pre-construction inspections. The municipality should be conducting pre-construction inspections. When they conduct their pre-construction inspections, they shall include the applicant or the applicant's designee. So they need to include either the operator or the operator, subcontractor, whoever they've hired to take care of their SWPPP services, and that person needs to be included in the pre-construction inspection. That pre-construction inspection may be conducted in person. The municipality can come out and do that in person, or they can opt to do it through electronic site inspection if the contractor also agrees and provides those sufficient photos for the electronic site inspection. We'll talk about the electronic site inspection here in a second. The municipality also must develop, publish, and implement standard operating procedures, SOPs, forms, or similar for construction site inspection. So they need to have available forms or SOPs in order for the contractor to use those for their construction site inspections. Now, the operator is not obligated to use the forms or SOPs provided by the municipality if they have their own other mechanisms that meet the requirements of the the federal and state requirements. So if a municipality says, hey, here's our form, they need to provide that for the operators so that the operators have something to use. But if the operator has a different form or a different program or a different system that they use, as long as that system meets the federal and state requirements, then the municipality has to accept that. They're not allowed to require the use of their specific systems or forms. Now the electronic inspection requirement, the municipalities must conduct oversight inspections through an electronic site inspection. Now, what that electronic site inspection is the operator providing geolocated and timestamped photos sufficient to meet the requirements of the municipality's oversight inspection, through an electronic means, through sending those pictures over to the municipality. Now, if you opt to do this, if as an operator you choose to conduct these electronic site inspections and send them to the MS4, you will want to take a look at the municipality's, the MS4's inspection template, which the state has also provided. And you'll want to make sure that you are meeting those standards. The state has also provided specifically an electronic site inspection template so that you can make sure that you are meeting the standards of the municipal oversight inspection. And so if you choose to do that, you can take those pictures, make sure that you meet that standard, send it to the municipality, and the municipality must conduct their oversight inspection using those pictures. Now, there are specific situations where they don't have to use that. Number one is if the applicant opts out, if the operator decides not to do that. If there's evidence that the photos were altered, they also don't have to use that electronic site inspection. If the electronic site inspection was not submitted on time, if the site is within half a mile of a river, stream, or lake, or if the site is a state transportation or military project. And then finally, the last requirement is that only the municipality or the authority that owns the municipal system that accepts runoff from a construction site may require post-construction maintenance agreements. No other municipality can require that, which kind of makes sense. Okay, now I want to mention quickly in the last minute or so the 3 important changes that were in the 2024 construction general permit update. Number 1, there was clarification that perimeter controls only need to be implemented downslope of disturbances. Now there may be other cases where perimeter controls are needed in other areas, depending on if you have a run on to your site or if you have other pollutants that may discharge. But specifically, perimeter controls for erosion and sediment control only need to be installed downslope. So that is even if your civil plans, your erosion control plan designates that silt fence will be wrapped around the entire site. If it's not necessary to prevent pollution or erosion, then you don't have to install those around the entire site. Okay. Great update to the language by the state there, making it very clear that, yeah, sometimes the erosion control plan, the initial erosion control plan and the civil plans, is far too stringent, and those requirements, kind of are unnecessary. Number 2, the language for track out pads for individual lots that is currently in the common plan permit has been extended to the construction general permit. So if you are typically building individual single lot residential homes on those individual lots, a track out pad is not required if you put in a prohibition of vehicular traffic onto the site other than for unloading and delivering materials. In which case, as soon as those materials are delivered and offloaded, then any track out that occurs must be immediately cleaned up. And if that is the case, you have that prohibition and you immediately clean up anything after unloading materials, then you do not have to have a track out pad on each individual lot. The third thing I want to bring up is material storage. There was some change to the language to make it clear that material storage that may cause pollution must be covered. So, for example, if you have stucco or concrete bags, stucco mix or concrete mix bags or something like that on site, those can cause pollutants to enter the water bodies, so they have to be stored indoors or covered. If you have a couple of other things that were specifically brought up is things like rebar. Rebar is going to rust. So if you're storing rebar, not the rebar that is currently in your foundation, but if you're storing rebar, it can rust, and that rust can run off and pollute water bodies, so that needs to be covered. Treated lumber also poses a risk to water quality and needs to be covered. However, things like untreated lumber do not, because they don't pose a risk to water quality, so that you can leave uncovered. So those are some updates from the permit, and that's the law that we went through. We're right on time. We have about 3 minutes for questions if anybody has any questions. Otherwise, I have my contact information up on the screen, so please reach out to me with any questions that you have. Any questions so far? Okay, sounds great. Thank you so much for joining us today. If you do have any questions, please feel free to reach out to myself or to my team, and we will make sure that we get you that information. Other than that, hope you have a great day. Thank you.